seat?
Did she contact you?
She being,
The defendant?
well, we had a meeting, sorry.
All right.
Thank you, folks. Please be seated. Our county court is now in session. It is July 16, 2013, calling case 13 CR 36, People of the State of Colorado versus Melissa Miller. Good morning, Ms. Miller. I'll be handling your advisement today. Let's go ahead and get defense counsel's entry on the record. Good morning, Mr. Seller.
Morning, Your Honor. Riley Seller from the Public Defender's Office appearing with Ms. Miller.
Thank you, sir. You've had a chance to meet with your client prior to this court hearing?
I have.
I'm going to go through a standard advisement, and then if there's any additional issues, you can raise those after that. Ms. Miller, you are accused of committing the act of second-degree murder within Park County. You are presumed innocent. The presumption of innocence will remain with you throughout these proceedings. The state, through the 11th Judicial District Attorney's Office, has the burden of proving each and every element of the offense you're charged with beyond a reasonable doubt. You are entitled to the presumption of innocence throughout these proceedings, and I will honor that, as will the district court. You do have the right to remain silent. Any statements you make in open court are recorded and may be used against you. You have the right to be represented by an attorney. Today, you're being represented by the Public Defender's Office. They will continue to represent you so long as you are in custody and wish to have them on your case. If you do post bond and you want the public defender to continue representing you, they will assess your financial circumstances and let you know whether you qualify for their services. You do have the right to know the elements and possible penalties for the charges you are facing. I'll explain those in a few moments. If you decide to enter a guilty plea, it must be a knowing, voluntary, and intelligent plea, not the result of any undue influence or coercion. You also have the right to a speedy and public trial. That can be a jury trial or a trial to the court. You're guaranteed a trial within 6 months of pleading not guilty, though that deadline may be extended if there are delays caused by your defense. Furthermore, you have the right to post bond while you're awaiting trial. We'll be addressing your bond level and your conditions today. You also have the right to a preliminary hearing within 30 days of requesting one. The DNA sample taken from you upon arrest will be destroyed by the state if you are acquitted of all of the felony charges in the case. The court reviewed the warrantless arrest affidavit and did find probable cause exists to hold you on bond for suspicion of committing the offense of second-degree murder. That charge is likely to be brought under Statute 18-3-103, murder in the second degree. It's defined as a person knowingly causing the death of another person. This is defined as a crime of violence. The presumptive prison term, if you are convicted of this offense, would range from 16 years to 48 years in prison, maximum possible fine up to $1 million. I'd like to hear first from the people. Good morning, Ms. Everling, Mr. Sullivan. Good morning. I'd like to hear recommendations regarding bail and other bond conditions.
Judge, if I could, I'd like to call Detective Bart Slasky to the stand, specifically on whether or not this defendant has ties to the community.
Yes, come on up, sir. Good morning, sir. Before taking any testimony, I'm going to ask you to raise your right hand. Do you solemnly swear and affirm under penalty of perjury that the testimony you give today will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead and have a seat.
Sir, would you state your name and spell both your first name and your last name?
Mark Slavsky, M-A-R-K-S-L-A-V-S-K-Y.
And how are you employed, sir?
I'm a police officer for the city of Wheat Ridge, Colorado.
Okay. And how long have you been employed in that capacity?
I've been there 33 years.
Okay. Sir, have you been one of the detectives assigned to investigating the missing person status in this case concerning LeAnn
Yes,
Myers? And are you aware that she went missing in February?
yes.
Okay. And when was her body discovered here in Park County?
July 4th of this year.
Okay. Sir, when you determined that the defendant should be arrested in this case, did you do some background checks concerning her employment status?
I was aware of her background.
Okay, and tell the court whether or not she's employed.
At the present time, I do not believe she's employed.
Okay. And what can you tell the court about whether or not she's filed tax returns in recent years?
To my knowledge, she has not.
What can you tell the court about whether she has a permanent residence?
Since this investigation began, she's been staying with her parents in Lakewood, Colorado. To the best of my knowledge, she does not have her own room there. She's basically staying on a couch in the living room and kind of living out of a bag of belongings. Prior to our involvement, she was living with LeAnn Meyer in the residence in the basement.
Is it fair to say that she was couch surfing?
I believe that would be fair to say since our involvement, yes.
What can you tell the court about her statements that she might commit suicide?
I can say that she attempted suicide in the early part of this investigation, I believe in the late part of March. She told me yesterday that she is not suicidal.
Okay. Judge, just to shift gears a little bit, we're also going to be asking the court to seal both the arrest warrant in this case and 2 search warrants that have been filed in Park County. And I'd like to ask the detective some questions about that, if I might.
Go ahead.
Sir, are you advocating that both the arrest warrant and the 2 search warrants filed in Park County be sealed?
I am.
And explain to the court why that is.
I believe they contain information that is very critical to the follow-up investigation that needs to be conducted, and that the release can compromise the investigative efforts.
Okay. Did you file several search warrants in Jeffco?
Yes,
And were all of those sealed
everything has been sealed.
pursuant to court order?
Yes.
Okay. Thank you, sir. That's all I have.
Mr. Selleck, would you like to question the witness?
Just briefly, Jim. Detective Slavsky, you mentioned some background checks that you conducted with regard to Ms. Miller. Can you describe what those background checks were exactly?
Not only NCIC, CCIC, but different internet database searches, court record searches, requests of state agencies.
Okay. Was the purpose of your investigation to determine Ms. Miller's ties to the community, or was the purpose of your investigation to investigate the death of Ms. Meyer?
At the time all that was conducted, it was to investigate the missing person, LeAnn Meyer.
Okay. And you happened upon this information regarding Ms. Miller during that investigation?
That's correct.
Okay. Thank you.
Severling, any additional questions?
No, sir.
Thank you, Mr. Slavsky. You can return any other evidence before making your recommendations regarding bail and bond conditions.
No, sir.
Go ahead with your recommendations then.
Okay, sir, the bond schedule for a Class 2 felony is $50,000 cash or surety. But you'll notice that under the bond schedule, it doesn't specify second-degree murder. It's just a generic Class 2 felony. I contrast that, Your Honor, with internet sexual exploitation of a child, which is $50,000 cash only. And given the nature of this offense, given the fact that this defendant has no ties to the community, we're asking the court to set bond in the amount of $50,000 cash only, rather than 50,000 cash or surety.
And are you recommending any specific bond conditions?
Judge, we would ask that she turn over any passports she has, although I don't know that she has any, and that she would sign a waiver of extradition prior to her release.
Would you like to make a statement regarding your client's bail and or bond condition?
The defense is not fully prepared to address Ms. Miller's bond at this time. I anticipate setting up a bond hearing at a later time. I'm just going to ask the court to set the bond at schedule. I do anticipate that we'll be able to present some testimony with respect to Ms. Miller's ties, perhaps not to Park County, but certainly her ties to the Weaverton and Lakewood area, and be able to establish that she's not a flight risk. I think it's, at this time, prudent to set the bond at schedule, and that's what I'm asking the court to do.
Ms. Miller, you've had a chance for your attorney to make a statement to the court. Would you like an opportunity to talk to him before I rule on your bail and bond, or is there anything you would like to tell the court directly?
No.
Considering the factors presented by the district attorney's office regarding your lack of permanent residence within the state of Colorado, lack of any proven employment, I do think it's appropriate at this point to exceed the bond schedule. We'll set bail at $50,000 cash only. I'm going to make your bond conditions as follows: that you not leave the state without permission, that you sign a waiver of extradition as a condition of your bond, that you turn over any passports that you may have in your name to law enforcement as a condition of your bond, and furthermore, that you are on global positioning monitoring while you're on bond. Other bond conditions are standard: no alcohol or drugs, no weapons, and no committing any felonies, and appear for court on your next scheduled court date. Regarding the next return date, counselors, I'll defer to some degree to your schedules. Ms. Eberling, since you'll be traveling up from Canyon City, I'm not sure if you've already contacted the court staff to look at appropriate dates.
I haven't, Judge, but I will be here next Monday, July 22nd, and I know that's a public defender day.
Mr. Selleck, would you be available to come in on the 27th at 22nd at 1:15 in the district courtroom?
And that would be for on hearing, Judge? And that's for a little more time, I think. Just one more week, I think. Just
for setting up.
Just for setting. That's fine. I'm available next Monday.
All right, let's set the case over for the district court on July 22nd at 1:15. Mr. Sullivan, I know that conflicts a bit with your county court duties, but we'll just do the best we can.